Well, good morning, everyone. Welcome to the Committee on Professional Responsibility and Conduct. And I will remind everyone that the meeting is being recorded. Angela, would you please take the roll?
Yes. Sarah Manola.
Here.
Elizabeth Bradley.
Here.
Raquel Brigham Brown. Cassidy Chivers.
Here.
Mary Grace Guzman.
Here.
Brandon Krieger.
Here.
Joel Mark.
Here.
Eleanor Mercado.
Here.
William Munoz. Daniel O'Reilly.
Here.
Akita Poindexter.
Here.
And Deepika Rodney. Thank you.
So, and just Raquel is here. She might have stepped. Oh, now she's here. Okay.
I'm here. Thank you.
Thank you.
Great. So next on the agenda is the call for public comment. Angela?
Okay, for those who are participating with us by Zoom, please use the raise hand function at this time if you'd like to make a public comment. And the State Bar staff will call you in order that the hands are received. For those that are participating by phone, please press *9, star and number 9. Each speaker will have 3 minutes and there will be an on-screen timer that will begin as soon as you start your comment. You will be verbally alerted once you have 30 seconds remaining, and at 3 minutes, your speaking time will be over. So at this time, if you'd like to make a public comment, please use the raise hand function. So I do have a Neil Reichstrin. Neil, I will allow you to speak. Go ahead.
I apologize for the Neil Wrightson on the Zoom. That's my husband's Zoom, and I didn't sign back in when I got on. My name is Lori Taylor, and my bar number is 1282225. I am urging COPRAC to move forward with its opinion on the ethical issues faced by lawyers who work to ensure access to abortion, as outlined in a draft at the March meeting. Ever since the Supreme Court reversed Roe versus Wade in 2022, a committed group of California bar members, including the Overarching Reproductive Law Project, the Center on Reproductive Health Law and Policy, and the Southern California Legal Alliance for Reproductive Justice, has worked to make sure that California lawyers can engage in reproductive justice work without fear of professional repercussions in California. Right now, a number of restrictive states ban abortion outright or early in pregnancy. Other states ban abortion pills and telehealth and impose other medically necessary restrictions. And state and local governments are proposing bans on travel out of state for abortion care. Those of us who advise clients in those states on how to get reproductive health care, or who want to help individuals travel to California for abortion care, want guidance from the committee about how their work might interact with their ethical obligations under the rules. We take an oath to support the California Constitution, which states that abortion is a fundamental right, and we should not face professional consequences for honoring our oath. We look forward to an opinion along the lines of the issues outlined draft in March, so that we can work for reproductive justice without fear of discipline. Thank you.
Thank you, Lori. Okay, the next public comment is from KM. KM, I will allow you to talk right
now. Can you all hear me?
Yes.
Okay. Good morning. My name is Kevin Moda, and actually I'm calling to comment on the proposed fee and the reasonableness of it that is up for discussion today. I'm in a very contentious legal bout with attorneys who kept me in a lawsuit when they knew that I didn't have a valid opponent, meaning that they lacked standing. And so they took 2 years, collected the fees, and then they left the case, and I ended up hiring someone else, and that case ultimately resulted in a substantial judgment in my favor. My point is that when I'm combating my former attorneys, in your rules, you state the attorney. but the way that the attorneys combat the situation is they leave who is making the entry blank. So all that it says is that attorney fees $250, but no one knows who made that particular entry. So I can't have my attorneys cross examine whoever it was that made the entries on a $500,000 bill. And by leaving, by just adding the words, the attorney who made the entry rather than the attorney, which most attorneys use synonymously in their retainer agreements as the entire law firm, then come up with clever ways of avoiding the responsibility to comply with, hey, I made this time entry and I spent this much on this date and is contemporaneous. And it also, by leaving that void, there's no way that someone without having a name of that attorney in that billing statement be able to tell their amount of experience of the person who did this, which is required under your rule 1.5, the experience, reputation, and ability of the lawyer or lawyers performing the service, and if the attorney is, when it says whether the lawyer has failed to disclose material fact, it leaves all those issues ambiguous. So I implore you that when you're looking at the fee situation and putting out your final rule, that you add that little inclusion on it. That's all. Thank you.
Thank you. Is there anybody else who'd like to give a public comment? Please use the raise hand function. I don't see anybody else.
Thank you, Angela. So I guess the next item would be approval of the June 21 minutes. Does anyone have any proposed corrections or modifications? And if not, may I have a motion and a second for approval?
I'll move.
Second.
Okay,
Angela,
also-
please take the roll.
Sure.
Thank you.
Here's the vote to approve the June minutes. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond,
Yes.
Mark, Joel, Mercado.
Yes, I'm sorry.
Yes.
Thank you, Joel. Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Yes.
Ravi, and Krieger.
Yes,
All right, so the motion carries with 8 in favor.
great, thank you. So next is my chair report, and I usually don't have much to report, but I want to take some time in my final meeting as chair to acknowledge some members who are terming off and thank them. I'll start with Hunter Starr, who actually resigned a few months ago, but gave us a lot of important contributions, and we really are grateful for it. And he was the genesis for an opinion we're still trying to carry across the finish line. And we miss his expertise, but I want to give our thanks to Hunter. I want to talk about Joel. And Joel and I have worked on committees together for many years. Joel will be terming off. This will be his final meeting. Joel has been incredibly valuable and hardworking on this committee. I appreciate his contributions enormously. Although he's going to hunt me down afterwards if depending on how the conversion clause opinion turns out. And last but not least, Sarah, who after serving valiantly as chair has worked just as hard. I think we're going to have to do a lot to fill the vacuum from her departure on the amount of work and thoughtfulness she's done as advisor. So thank you, Sarah, as well. we're gonna have some new members coming in, and I will be in what is, the advisor status. I won't be able to vote on anything, and you won't have to listen to me nearly as much. So that's gonna be amazing for everyone. So Cassidy is gonna be the new chair, and Dan O'Reilly will be the vice chair. And so they're gonna do an amazing job. And we are, Vikita has been reappointed, which is excellent. So I don't know if that counts as a new member or what a reappointment is. I'm not qualified to opine on that, but I congratulate and welcome Vikita again. And then we're gonna have 3 new members. The proper time to introduce them, I suppose, is the meeting that they will be attending next month. But it's Emil Ali, Novella Coleman, and Carrie Riley. And they're gonna be great contributors to this. So that's my chair report, my final chair report. Erica, you have a report, don't you?
I do, but I'll just echo what Brandon said and thank everyone who has contributed so much to the committee over the past couple of years. I've been with the committee now for just over 2 years, so I feel like I've had a good opportunity to work with each of you as well. And then I also want to give just a thank you to Brandon for his year as chair, and we've accomplished quite a bit in the past year, in large part due to his leadership. So thank you, Brandon. And now you have the task of becoming, doing all of that work that Sarah's been doing as an advisor. So I think a lot more to come. So very briefly, just staff report. As you all may recall, back in June, this committee voted to approve Arbitration Advisory 2022-OXA. That will be renumbered, but it's going to be before the Board of Trustees at their meeting next week. That was the first meeting for which we could add that to the agenda. So next week it will most likely be adopted, and then that'll be a new arbitration advisory, or a revised arbitration advisory, essentially, because it's superseding a prior one from 1993 that will be posted. For those of you who are curious about what's going on with sub-entity review, it is still ongoing. There is likely to be some surveys and interviews coming up next. So you may actually be contacted to provide some input in regards to your work on the committee. And then finally, again, in June, this committee voted to not recommend any changes to California's version of Rule 1.16. The ABA has made changes to the model version of that rule that the working group and then ultimately the committee decided to not adopt. So that information was conveyed back to the ABA that California is declining to move forward with the same changes to California's version of 1.16, and was also conveyed to the California Supreme Court.
Thank you, Erica. I'm happy to hear more talk of sub-entity review. I thought it was an urban legend. In my 1 year as chair, I have had 0 encounters with this supposed sub-entity review. So thankfully it won't have any input from me. Let's move on to the first item of business, which is everybody's favorite subject of harmony and agreement, the conversion clause opinion. It went out for public comment, and we got some really interesting public comment, which was the goal, right? A lot of people on this committee who were very clear in that they did not support the draft as written were willing to vote it out for public comment so that we could digest and analyze the responses. And the responses from the non-committee responses, there wasn't that much, but some people thought it was, yeah, these conversion clauses are never permissible. One called it a bait and switch. Some people had slightly more nuanced takes. But I want to talk just a little bit about the 2 committee letters we received, the comment letters from the California Lawyers Association and from LA County Bar, both of which had some really thought-provoking and significant criticisms. Again, that's really kind of what we were seeking. A couple preliminary points. There's 3 people on the working group. Joel is rolling off. Joel has done a huge amount of hard work. He's leaving. And Deepika is the other member along with me. I'm going to be a non-voting member of this committee next year. So Deepika, who couldn't make it to this meeting, is looking forward to taking more of a leadership role on this opinion. So I figured what we would do is talk a little bit about this comment letter in this meeting, but maybe go in depth even further in the in-person October meeting where Deepika's there. We'll have our new members and see what the committee really wants to do with it. But I'll give a brief survey of the California Lawyer Association comment letter and the PREC comment letter. And then I will invite Joel to speak because Joel has put in a lot of hard work on this matter. So both committees had concerns about our definition. It was not precise enough, and both committees seemed to think, as drafted, it was overbroad and would apply in situations where perhaps it ought not, specifically with regard to transactional matters. Both committees seemed to believe that, well, PREC believed, I believe, that we should separate out the transactional topic for a different opinion because it has completely different considerations. But there was a general sense that a lot of the client protection goals that motivate this opinion, and which both of those committees shared as well, really don't square in the transactional context. It just doesn't make sense. And both of the committees seemed to believe that there are permissible instances where with sophisticated clients or particular factual scenarios, a conversion clause may be permissible, even if those circumstances may not be that common, and thought we had gone, too far in that direction. There was considerable discussion of, they thought there was criticism of our inclusion or continuing inclusion of any reference to Rule 1.5 in the draft, which I have to say, I think is a bit of a vestige from the earlier drafts because it is out of place in this draft. It will not be out of place if we were to take the lead from these committees and again, walk back from a per se prohibition and look at case-by-case analyses. Then unconscionability is one of the factors that would have to be analyzed in each instance. So overall, and this Ramirez versus Sturdivant case that the California Lawyers Association brought up is thought-provoking and challenging to the current draft. In that case, an attorney, it's a complicated factual scenario, but in that case, the attorney was being asked to continue in a representation that the attorney had either already terminated or was about to withdraw from. And the attorney said, I'll only do it if you agree that the minimum you'll settle for is X, and if you don't, I get paid in some other way. And the court in that case said there was nothing overreaching about that. Now, PREC also, the LA County Bar also said that we are eliding ethical duties and court-made rules regarding what sort of contract terms are enforceable and how quantum merit would be employed. I'm not 100% sure I agree with that, but I found it very thought-provoking, something to discuss. So overall, these two committee comment letters suggest pushing back towards an earlier draft of this, which did not have a per se prohibition, but analyzed conversion clauses on a case-by-case basis and talked about the circumstances in which they may or may not be permissible. Okay, two other notes on these comment letters. One is that they both critiqued or thought we were using interchangeably quantum merit and unconscionability, which we weren't intending to, but speaks to a lack of clarity in what we were trying to communicate. So those are important points to listen to, even if we don't think they're responding to things that are intended by the draft. And I guess the other is really just having to do with the difference between enforceability and ethical propriety. That's my summation of these comment letters. Joel, did you want to speak a bit?
Thanks, Brandon. Yeah, I read the comments. I agree that they were interesting comments. I'm not so sure that I agree with all of them. And I to be honest with you, I really got to the point where I just knew that it was going to be pulled back for another round, and I figured I would leave that to those who follow, and I'll wait to see how much of it is left. You know my thoughts. I don't have to repeat them. I still think that the issue is a very important one in terms of client protection. And for all the reasons that I stated in all the drafts I did before, there has to be some protection for the client who thinks they're getting what is advertised. If there's no recovery, you don't pay, and end up signing something that says they got to pay something. So I haven't changed that view at all. And every time I see the 100 or so billboards between here in Los Angeles of those lawyers, it just reinforces my view. So I'll leave it at that. And I'll be watching from the cheap seats.
Thank you, Joel. You know, Joel and I, neither one of us ever gets to vote on this again. So we'll be gently nudging our points of view going forward. I open the floor to anyone else who wants to talk about it, but I do want to note that I really think this should be discussed in depth at the next meeting, and calls for additional members to join the working group should happen at the next meeting. But if anyone would like to chat about this now, I'm sure Joel and I would both be delighted.
Yeah, I would like to, since this is my last meeting.
Yes, yes.
And I know that, I think, I was one of the few, I know Justin left and Eleanor's still here, but that, I think my opinion of the draft kind of, I think, aligns with the two committees' comments that we received. I do think, the per se prohibition is overbroad. And I also think I thought you gave a great summary, Brandon, of the comments. The one addition I would add to that is just that I think the bottom line of both letters was also that, not all conversion clauses are unethical under the rules of professional conduct. And, they're only unethical where they clearly interfere with the client's right to settle a matter, or where they interfere with the client's right to discharge counsel. And I think those are very two important factors that we need to evaluate. And so I really agree that they're just not, that there's no like per se prohibition. And I also thought it was, the way they discussed, I know you mentioned equating quantum merit with conscionability. And I think they're viewing that because I do feel that the opinion does not analyze it currently under the ethical standard, which is whether it's unconscionable. And I do think that's the proper ethical standard where we should be looking at this. So one thing that I just wanted to mention going forward, if we're going to consider making any changes in response to these public comments, I know at one of the last meetings we had presented an outline that Eleanor and I had worked on as part of, the working group, and that goes into a lot of different factors to consider, and some of the factors that were noted in these public comments as well. So that might be useful to use. It seems like people are calling for hypotheticals, but one framework that I think if we're going to change it would be to start with kind of, these are the facts, if we're not going to go through a per se prohibition, these are the factors you should consider. And we have a pretty good summary of that, and then provide a few examples. And I thought the LA Bar Association provided a couple of great examples to consider if we're looking for hypotheticals for another draft. So that was, I think I've stated my opinion previously, but I just wanted to note that based on my review of the letters, which I thought the LA one really spent a lot of time analyzing the issues as well. And it's pretty detailed and helpful, I thought.
Brandon,
Yes.
Sarah reminded me of something that I wanted to bring up and I forgot. And that is the issue of, have we confused unreasonable with unconscionable? And that, I think, stems from the concept that if the added fee, the hourly rate after conversion is either prohibited all across the board or is inapplicable due to the facts, if that's the way it goes, then the attempt to collect it would be unconscionable. Does that make sense?
I think so.
In other words, if you're not entitled to it because your clause is not enforceable either as a matter across the board or because of the facts of your case, you haven't crossed that bar, whatever we decide would be permissible. If you're not entitled to it, then your attempt to collect it is unconscionable.
I see that point. I see that point.
I see what you're saying. I don't agree that that's true in every instance. There might be situations where a court finds it unenforceable, unrelated to whether it complies with the rules of professional conduct or the standards governing attorneys.
And it also, it wouldn't really be, it's sort of a fight we don't have to have, because if it's an impermissible conversion clause under the case-by-case analysis already, it's already ethically prohibited. But I see your point, Joel. I do see your point there. You know, one of the beauties of committee work is that after 4 years of hard work by so many people, the 2 comment letters indicate preference for something much closer to the first draft of this that went out like 2.5 years ago. So it's a, you know, it's a good feeling of satisfaction, time well spent, right? But we're trying to get this right. And I think the next generation, you know, the children are our future. These new members, you guys are going to do great. But I really appreciate everybody's work on this. I want to say that even the folks that I've been at odds with on substantive issues, I think everybody's bringing great insight in good faith on this. And, you know, these things take their own sweet time, and hopefully we get there. Raquel, I see your hand raised.
Hi, question and then a couple of comments. The second public comment person, KM, maybe this morning, was his comment about this item, or was it around a reasonable fee? I was unsure when he started speaking.
I have no idea. I think his comment was about a specific dispute, and
Right.
I couldn't track it to any particular agenda item, and that might be my failure. But
okay, the reason I ask is because it seemed, while technical, intriguing, particularly if it was related to this area. So that was a question. The other question is, remind me how we got to this. What is this? So what are we trying to solve? Because I realized we're asking people for a lot of comments, and we're even taking different positions on things, but sort of what is our North Star? And so when I hear Joel speak, I relate to what Joel's saying, which is he didn't say this is the North Star, but it's for the client protection. And so if that is the North Star, yeah, there's a lot of technical ins and outs, and, you know, you all are very versed in, you know, is it unconscionable, is it pro se or whatever, but I think that's the litmus test. Whatever we're saying, if it's for client protection, that to me, that's the principle. And so I realized I'm not sure sort of why did we start talking about this whenever, as you said, it sounds like maybe we started talking about before I got here. So I feel like we're in a lot of activity and everybody has a lot of point of views. But what are we trying to solve really?
yeah, and it was my, I'm to blame for bringing this to the committee initially. And it is a client protection motivation. Joel and I, in our practices, see a lot of fee agreements where someone thinks they're hiring a contingent fee attorney because they have no money, and they and the attorney says, you know, I don't get paid unless you collect and all this stuff. And then they get dissatisfied with that attorney and they want to fire that attorney, and the attorney points them to the clause in the agreement that says, oh, but if you fire me now, you have to pay me my hourly rates and stuff. Now, I think there's been broad support on the committee, generally speaking, that we all share this client protection goal. And the particular instances that Joel and I see that are upsetting would fail just about anyone's tests. So the real debate has been about, are we shutting the door on all conversion clauses? Or is that going too far and impermissibly messing up the contractual arrangements that don't really pose ethical problems? I do think we've all had the same North Star here, and it's just a question of what's the best way to solve our problem without creating new ones, right? So that would be my general. Does that answer, Raquel?
Yeah, do we have status, in other words, to be able to make an opinion that would make contingency fee be able to convert contingency? I mean, so that's sort of what I heard you say, and not well, that we could make something that could make it become not an option for attorneys to include in their contract. And so then I think I understood Sarah to give some reasons why we couldn't do that. So I'm wondering, are we trying to solve something that we really can't do anyway?
I think we can do public good. The question is, what's the right balance? How far do we go before we're out over our skis or before we're out over existing authority? So I don't think this is something that we can't move the needle and do some good on. That's my personal opinion. We just have to strike the right balance and do it in a way that we all think is intelligent and not too far. So, Raquel, do you have any more comments?
The new members are all attorney or public members? Do you
All
know?
attorneys, right?
Okay. Oh,
Okay.
darn. Because in some way, I mean, I think we could get into a lot of legalese, but this is one where in some way, common sense probably is what's going to prevail instead of getting into the technical. So public members sometimes can lift in a different way because we are looking in some way without the handcuffs of the legal profession and the laws and all of that. So time will tell. Maybe I will volunteer for the committee.
Okay, thank you. Thank you. So I've got some hands raised. Mary Grace?
Just speaking to Raquel's question, I do believe he was the gentleman caller that you were asking about. I believe he was speaking to this opinion. That's what I understood. Secondly, with regard to transactions, I agree with what LACPA is saying is, maybe we remove transactions because transactional stuff is, I mean, just working at a large firm, I find that even my lawyers at my firm don't always understand that transactional attorneys are, subject to the same matter, rules as litigation attorneys. They'll tell me, well, it's transactional, it's not really adverse. And I'm like, no, it's still adverse. So because of that, I think we'd either need to, I would agree that we need to remove transactional, limit it to litigation, because I think it'll also clarify some of the other concerns with regard to being able to choose your client, and that's, choose your lawyer, and also some of the settlement requirements that lawyers have when they have to disclose the agreement to the settlement and next stages. So I do agree with both LACPA's more explicit request and the California lawyers' discussion of transactions.
Great, thank you. Cassidy?
Yeah, I just wanted to, because I think I agree with Sarah about and those saying that there shouldn't be a per se rule against conversion clauses here because of, that they, well, basically like the example in the PREC letter. But the struggle is, how do we provide guidance to lawyers in determining, when it's ethical and when it's unethical, if we're not going to have a per se rule. So, and I think that guidance is really hard to nail down, as, evidenced by the time we've spent on it and the first opinion versus second opinion. So I'm thinking that the best guidance is not so much, I mean, we should have that guidance, how to recognize when you can and cannot use it. But if you do determine that you can use it, then the guidance should be, this is what the disclosure should look like, you know, kind of similar to when you're like an arbitration clause, you know, when you have to have it in bold and you have to explain it very clearly and you have to, you know, so it's not, you know, the situation where the client's coming in thinking, well, I thought this was a contingency and it's no fee, no recovery. Well, if the fee agreement is clear that that's not the case, you know, when they in conversion. So we would have not only an example where it's could be used, but also the language that so that would sufficiently you know, notify the client as to what the conversion clause is and how it operates, and even giving examples in the agreement itself. You know, I always think those are the best types of fee agreements when you have a complicated structure.
That's a really interesting point, and we haven't looked at that at all. So like the LA County Bar letter talks about informed consent, which is important and a great ethical framework tool that none of our drafts have dug into very deeply. So
Yeah.
That's a great point, Cassidy. So Eleanor?
I agree with Cassidy's point there. Everyone knows where I stand on this one. I don't support the per se rule. I would like to volunteer for the committee. And I think, you know, further to what Cassidy was saying, I think having disclosure examples, I also think maybe having examples, Joel mentioned, you know, the advertising he's seeing all the time. Maybe we could pull that into a hypo to indicate how problematic it is and how important it is to be clear, you know, in the fee agreement, giving the disclaimer, getting informed consent, etc. So I think, I do think we can be of good service here, even if we go in this direction of not a per se rule.
Great, thank you. Elizabeth?
I'll volunteer.
Great. Cassidy has to take note of that. It's not my job soon. I'm kidding. No, that's great.
I gotta put my hand down.
And so
Actually, you know,
Eleanor,
I would make one more
Yep.
comment before we lose people who've been thinking about this. I don't see a principled basis for separating out transactional work. I think we could deal with it in a separate, I mean, we talked about it at the last meeting, but I don't see, I think we ended up feeling like we could not separate it out on a principled basis. And I think maybe it'd be better dealt with in hypos. I don't know if people disagree, but I'd be interested in hearing thoughts on that.
that's actually really interesting because the transactional feedback that I heard was that it just doesn't apply. But I'm not sure the logic behind that is as convincing as the fervor that transactional attorneys thought this didn't apply to them at all. But I think that should be explored. I mean, either treated in the definition so that in the instance where it does apply to a transactional area, it should apply, right? You know, I thought some of the concern from some transactional attorneys I spoke with was unnecessary because the things they are concerned about wouldn't be considered conversion clauses anyway. But that is something for more specific inquiry, I believe. So I think Sarah had her hand next.
Thanks. I just following up, I think on Eleanor's point, I do agree with that I think we should address transactions here as well. I don't think we should say we're not addressing that. I don't agree that it necessarily, you know, it doesn't apply there. I think we could probably even include a hypo perhaps as well. And I think that might be a hypo involving where it's more of a sophisticated client, like a corporation, when we're dealing with a transaction. So that might be a good hypo to include. And I know, just following up on what Cassidy was saying in terms of how it's, you know, it's difficult to come up with just certain hypos and say affirmatively, this is when it's permissible, this is when it's not. So I think, you know, we should just try to select the best hypos we can, but also upfront give guidance in addition to the disclosures that I thought was a great idea. Also just all the factors. But the one other point I just wanted to briefly address is, I know there were a couple of comments about just, you know, the goal being client protection, which I agree with, but I don't think that goal is achieved by making them per se not permissible. I think doing that could actually pose significant access to justice issues. And there are many situations where it might be the client preference to have a conversion clause. And, there are just so many different instances. And I think, I can't remember which letter it was a LACBA or the California Lawyers Association, but also gave an example of where the client might have a non-monetary goal, right? And that might be a difficult situation, for a contingency fee lawyer to take that on, if you have this per se prohibition. But there are many other instances. So that's all. I just wanted to say that client protection can still be achieved without making it, making conversion clauses prohibited in all instances.
Elizabeth, did you raise your hand again, or is it from before? Okay. I appreciate everyone's input on this greatly. And I'm glad that there's still so much interest in coming up with a workable draft, that we're not just out of gas on this, because I do think it's very important. And I do think there's more than one way to craft this in a way that benefits the public protection goals. I really do. So, but I want to thank everybody for all their hard work on this for the last century and a half. It's been good. Okay, so unless there's any other conversion clause input, let's move on to item 4.8, which is Arbitration Advisory 2022 OXB. And I believe Elizabeth is going to present this item.
I am. I don't think it will be too long of a discussion. There's a lot of kind of overlap from what we've been talking about on the 1.5 and reasonable fee. So this advisory was to update the existing arbitration advisory where dealing with situations where there is no enforceable fee agreement. And the primary purpose of the revision was to, one, update all of the rule references to the current rules of professional conduct, and two, to incorporate the analysis from the Shepard-Mullen JM Manufacturing case, which gives guidance in the event that a fee agreement is voided due to ethical violations by the attorney. So it was interesting because we got comments from Orange County Bar with a few suggestions, but overall saying that this accurately states is in compliance with existing California law. And then we got a comment from CAOC saying this totally doesn't comply with California law. So I was a little perplexed. It took me a little bit to kind of drill it down and figure it out, but CAOC was, I think I figured out why, but it took me a while to figure out why they were asserting that we're improperly incorporating and relying on ABA Rule 1.5, which has a reasonableness language in it. When we're clearly quoting and updating the advisory to conform with California Rule 1.5. We have no reference to the ABA rule, no citation of the language in the ABA rule. And then I kind of figured out, backtracking, Orange County gave us a comment that we cite the Pesh case, which only applies where there is a contract. In that case, there is an enforceable contract. And there's some language in there about reasonableness of fees. And their point was, we don't really think that citation is wise to include because it might cause confusion as to that analysis versus the fact scenario in this advisory where there is no enforceable fee agreement. So I don't know if I'm correct, but my conclusion is that that citation, which is one of the first sentences after the summary to Pesh, caused confusion that we were relying on the ABA 1.5, which includes a reasonableness analysis. And so that's the only thing that I could really make sense of why CAOC would be taking that position. And it was a pretty lengthy, in-depth comment, which was perplexing. And so I am in full agreement with Orange County's suggestion that we not reference the Pesh case. And I do agree that it is misplaced and clearly could cause confusion on that. Let's see. Those were the main comments. So the other comment was that we mentioned in raising this issue of the analysis where there has been a finding that a contract is void for an ethical breach, that it doesn't quite make sense in the context of a mandatory fee arbitration, because there wouldn't have been a prior court determination that a fee agreement is void for ethical breaches, because it wouldn't be going to the MFA program if the court is making that determination already. So that made sense to me. That's not to say that an MFA arbitrator might not be called upon to make these determinations in an MFA proceeding if that issue is raised by the parties. So I want to give it a little bit more thought, but I'm thinking of just removing that reference to there being a prior court order that the fee agreement had been determined to be void. And I was one of the counsel in the JM case after Shepard Mullen, after the Supreme Court remanded it. And in that case, it was contractual arbitration, not an MFA. So it made sense that there was a court determination on the validity of the arbitration agreement within the fee agreement. I don't think that would apply here under the MFA proceedings, but I'm open to any comments or discussion or advice on that issue or any others.
Thank you, Elizabeth. I think Joel has his hand raised.
Yeah, 2 points, because remember, this is an advisory. We're not talking about an ethics opinion, directing. We're just advising arbitrators what to do. The reason that the Peck case, I think, should remain is that what that made clear is that where you have a complying contract and there's been no other breaches or problems with it, the arbitrators are constrained to apply the contract rate and not consider the reasonableness unless you get to unconscionable. So it's important in this advisory to point out to arbitrators that they've got to resist the temptation when they've got a complying contract to say, well, I don't know if it was reasonable, and then go into a reasonable value calculation when this court decision in Peck says you don't have jurisdiction to do that. That's the wrong standard. And that's why it's important to mention the case. And if you want to clarify where it doesn't extend or what your reference is to Rule 1.5 or whatever, that doesn't apply. But the importance of the Peck case is to point out to the arbitrators that you're in a different standard where you've got a contract as opposed to when you don't and have just a reasonable value standard. They're different. And that was the whole point of the Peck case, and it's important to tell the arbitrators that. The second comment I have is about the rules of professional conduct. And I just grabbed my statute. I think 6200, 6203 specifically tells the arbitrators that they are to consider breaches of professional duty, of rules of professional conduct, Yeah, 6203A, evidence relating to claims of malpractice and professional misconduct shall be admissible, but only to the extent that those claims bear upon the fees, costs, or both to which the attorney is entitled. So I would not remove any reference to consideration of the rules of professional conduct, even if it's a matter of first impression for the arbitrator to whom this advisory is addressed. They are supposed to, under the statute, consider whether there's an ethical violation, and if so, whether that makes the value of the services less or it otherwise affects the right of the attorney to collect the fee that they're looking to collect.
Thanks, Joel. I didn't mean to say that anyone suggested or that I agreed to not mention evaluation or consideration of claims of misconduct. I think the only issue was whether we're identifying where there was a prior court order voiding the contract based on misconduct, and and just removing that reference and still giving the arbitrator guidance like you just mentioned. In fact, I think inclusion of a reference to 6203A would be helpful to insert the way that you just read it. I think that would be helpful just to give the arbitrator a little more more authority and guidance on that. And maybe on the, I don't know, is it Peck or Pesh? I've always said Pesh, but anyways.
I've heard it both ways.
Okay. I'll look at if there's a way that we can leave it in, but clarify, remove any potential confusion. So, and maybe even specifically calling out that we're not citing to or relying on ABA Rule 1.5, and that case is acknowledging that case is applicable when there is a existing fee agreement. To leave it in there, but remove the confusion would be my goal.
Sounds good to me.
Okay, great. Anything else?
All right, well, thank you very much, Elizabeth.
Great.
Appreciate
you.
it.
Thank
You and I might want to invite in the next meeting another member to our drafting group, but we can cross that bridge later.
Okay, great.
Thanks, Elizabeth. All right, so now we're going to move to item 4.6, which is a discussion of draft opinion 20-0003, flat fees and termination. And Joel is going to present this item.
Thanks. Whoops, what did I do? Oh, screen sharing, here we are. Yeah, a case came down in July called Dixon versus Mann, which really covered a number of the questions raised in this interim opinion, and I think supported the opinion. And the case involved a situation where a company was considering bankruptcy, and it with the attorney, they put $585,000 into the attorney's trust account, and then they filed bankruptcy. And the question was the $585,000 a deposit to be held for the client, in which case it would revert to the jurisdiction of the bankruptcy court, or was it a flat fee for future work that the attorney was going to do for the client to guide them through their bankruptcy travails? And the court essentially said that it really didn't matter because the attorney hadn't done any work yet, or had done, I think, only $50,000 worth of work. And unless you do the work, it's unearned. And whether it's in your trust account or in your general account, it reverts to the bankruptcy court because it is now the property of the creditors. So I wanted to revise this to take into account not only the public comment that we received, but also that case. And I just didn't have time to get it done. And what I was hoping we could do is, after we have a discussion here, you might extend my sentence on COPRAC for another week or two, so that I can just give you a final draft that incorporates the public comments, the case, and anything that comes up in this discussion. And then I will fade off into the sunset.
Erica, doesn't Joel, isn't he a member all the way until October?
I believe he's a member. That's our next meeting. Technically, I think it's end of September, but that is probably enough time
Okay.
on Joel's schedule. I'll just say though, I think most, I mean, Joel, please review it again, but I think most of the public comments were incorporated. Staff was directed to add them to the opinion at the June meeting. So that case would need to be added, but and then obviously a re-review. But otherwise it shouldn't have too much more to go.
Yeah, I wasn't planning on anything extensive because, as I think I told you, Erica, I thought we were pretty much finished with it, except for this case. But I hadn't fully read all the public comment at that point. But is all right. I will consider myself still on the hook to give you a revised draft, including to the extent that this Dixon case is applicable or helpful, and then you can all take it from there.
Fantastic. Joel, thank you very much. And this is another opportunity to thank staff for doing all this great revision work on this as well. I think that's really valuable and we appreciate it. Okay. So unless anyone has any thoughts on the flat fee draft, we'll move on. All right, the next item is draft opinion 20-0002 succession planning. And Dan is going to talk about this one.
Thank you. We did staff revisions, and then the working group got together last week to go over them. There were a couple of minor revisions. We did change the sort of intro and a couple things that the committee should just sort of look at and approve. For the most part, as I mentioned last time, the comments were related to the fact that they didn't love some people didn't love that we did any kind of obligation. Some people didn't like that we didn't go far enough to make it compulsory that you have to do a succession plan. So just as a reminder, we ended up on a balanced approach where you have an obligation to assess whether you have to create a succession plan. And so that's what you still see here. We made some revisions that cleaned up prior drafts, vestiges, and things along those lines. And we can walk through them, or if everyone has already sort of looked at this, I don't think there's any substantive change. And Erica and Cassidy, correct me if I'm wrong, but the revisions were just either stylistic or clarification for the most part.
Yes, I think that's correct. Sorry, I lost my screen.
There is a new digest draft, which is just, again, intended to be just a clarification.
Are we planning on, we're not planning on voting this out today, are we?
I can speak to this,
Are
but
we?
it could be. And to what Dan described, there's no need for this to go out for an additional public comment. So I don't know if that makes it scarier to vote it out. But so there's no, this is it. So there's no significant substantive change to what's previously been in here. It's again, just that there's a duty to assess. And then depending upon that assessment, an individual may also have a duty to establish a succession plan, or they may not. So if the committee has reviewed the opinion and is in agreement with that, it would go to the Board of Trustees for approval at its November meeting. There is an option to, wait and approve this at the October meeting. It's just, for what it's worth, it's a much tighter timeline for staff because board items for the Board of Trustees are due very quickly after that meeting, if not before that meeting, actually. But I don't want that. Again, it could go on a different board meeting as well. I don't want that to be the decision if people haven't reviewed it yet.
Well, I mean, we had our subcommittee or working group meeting last week. I didn't have any qualms about it going forward. I don't think Dan and Erica did either, but I won't speak for them. So I would be in favor of voting this out today. There's no reason to hold it up, I don't think, unless there are some specific issues that anybody might have once they've after they've reviewed it.
I agree with that. I mean, the comments were helpful in certain instances to clarify things, like always in the drafting process, things remain that are from previous drafts, which we corrected, but I'm comfortable and I think that it's ready to go.
Well, let's, who wants to, oh, Raquel?
You're mute.
Yes. I feel the idea of just taking it, I mean, I know how we got to just say duty to assess, but I think it's again, from a client protection standpoint or a public protection standpoint, I just think it falls very short. Because, those who don't want to do it, they'll just look at our framework and say, yeah, I didn't have to do it, and they won't do it. And so the biggest, again, the public is the one that suffers because the lawyers feel like it's too onerous. So, and again, it'll be the small people. So it's not going to be someone that's with a large firm. It's not going to be someone who can really afford legal counsel at a even medium level. So I know that was a decision that's made, but I do think it's a shortcoming, and certainly, I don't think we had anything. So perhaps this is step one, and we'll be able to revisit it. Look at, I think we don't even have a way to know that people are doing it or not. So we don't have a good assessment mechanism as to even how it's working. But I think it leans too heavily in the direction of attorneys, and the purpose again is protection of the public. So, but
that's right. Thank you, Raquel. That's a good point. Of course, the tension that we experience with the balance, but one additional fact that might be a next step is that Erica mentioned that staff is working on a kind of a compendium of things that could be in the succession plan. So is that correct, Erica? Did I say that wrong?
No, you're correct. So that's staff is working on it behind the scenes, but that will come to this committee, not for like formal approval, but obviously we would want you all to weigh in on what that looks like.
And the idea is like if there are examples, and if you were a solo and you felt it was if you were resisting it because you thought you didn't know what to do, if there are resources that we can provide that are really practical, then it would remove some of those barriers.
And then aren't we, so even if it does get approved and then this guidance comes out later, we put like a banner at the top of the opinion to reference it. So it will be, we don't have to wait for it basically to vote out the opinion.
So like a template, Erica, is that what you're thinking? Just and I'm thinking template like one page. So I'm using.
Yes, some context might be helpful here. So the ABA requires in a comment that certain lawyers have succession plans.
Right.
There are other jurisdictions that require attorneys to have succession plans. Essentially, it's where they require somebody to name another attorney that may take it over. Anecdotally, what happens is they do that, and then that's it. That's the end. And it's, you know, that person that they've named may no longer practice. They may retire themselves. It's not updated. So it's compliance in name only, essentially. That's what's occurring there. The state bar currently allows for licensees to name an optional contact person. It does not have to be an attorney that the state bar can reach out to if that person passes away or is unavailable to communicate with regarding their practice. So it's currently an option, but it's just a name at this point. What I think we're all discussing here is something more robust than that, is so that people understand what they should do as it relates to client trust account information, what they should do as it relates to client files, what they should do as it relates to calendar management so that they're not prejudicing the client. So I think what we're looking at is something more robust. I do think like a one-page, here's what you need to do would be helpful, but I also think it could be more than that. You know, I think there's two things. I think a one-pager would be very helpful, but I also think that for those who want a true succession plan, it's not maybe sufficient other than to identify the steps that they actually need to take.
And when is staff thinking they'll have that ready?
It is being looked at and worked on in conjunction with kind of just law practice management resources more generally. So we have currently on our website, senior lawyer resources is how it's described. Our thought is that instead of it being targeted to older lawyers or lawyers who have this for a longer period of time, that it'll be rebranded essentially to make it clearer that this is a succession plan opportunity for all attorneys, not just those who are closer to retirement age. So the answer is a couple months probably.
Okay, so the reason I ask is because it seems like if it's closer, like we haven't had this opinion, so there's no real reason to rush it. If we know we have something that would be helpful, release them at the same together.
Yeah, I wouldn't want this to be held up by that. I don't think, unless that's a strong desire of the committee, because there are other resources that exist elsewhere on this topic.
Is there some reason we're rushing it? I mean, is there some reason there's a time element to this, getting it out, besides we've had it a long time? I mean, no one's waiting for it, right?
I assume that the whole of the California bar is breathlessly waiting for all of our opinions, but beyond that.
Right.
Nothing specific.
Give it to us. What's wrong with you? So
it's like a new Apple product.
You give people more likely to take the actions we want them when we give them what they can completely do with whatever we give them. So I think you give them this and then later you say, oh, go look over here. You lost their attention. So there
are ABA resources that we cite in the opinion that exist right now that people could go to, and they're essentially more or less what I think the California bar version would be, something similar to that. So if you had questions and you click on that link, which is in one of the footnotes, it would take you to a practical guidance about what you, even just identifying the categories of things that you have to determine could be done. So I don't know when the staff practical guidance would be out, but the ABA one would function in the meantime. It's a good point that it's easier to give someone the duty and the way to resolve it, but these resources have been out for a while.
Erica, do we do any memo with the release of a new opinion? So like if the board were to approve this, can we, when it is published, or can it say, the state bar will soon be releasing X as well?
Yeah, so we don't do like a formal news. I think we used to do like news releases that were posted on the website. The world doesn't really read those types of things anymore. So what happened was our communications team does several different things. They post things on social media. There's an all licensee email that goes out, in which like 8.3 obviously went out that way. Those types of things go through the all licensee email. So it could certainly be part of that and indicate, you know, for now, here are resources you can look at coming soon, you know, California specific succession planning resources.
Okay. I mean, that might be a useful measure as well. When the communications team talks about it, to say, you know, we've got this new opinion and we will be also providing, you know, checklist of guidance, practical application sort of too. So, look, I want to defer to the drafting team. I think Raquel makes some very good points, but there are lots of resources referenced in the opinion as well. So, you know, we could move this out now, or we could wait. But if the drafting team wants to make a motion, that's fine too.
I would move it out now.
Okay. So do I have a motion?
I make
Is
the
that-
motion.
All right, second?
Second.
Okay. Angela?
Sorry about that. I will take the vote. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond,
Yes.
Mark, Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Yes.
Ravi, and Krieger.
Yes.
So the motion carries unanimously.
Well, I would like to congratulate and thank the drafting team and staff for all the hard work on this. It's useful, it's beneficial, and it's always great to actually complete something. So thank you. All right. Next on our agenda is opinion 2021-206 colleague impairment. And these are the updates that Erica and staff have been working on. So Erica is actually going to present this item.
Great, thank you. So very high level, basically what were the updates here is that this opinion, which was issued about 3 years ago, had a section that said that there was no version of Rule 8.3 in California. And now obviously we have one as of about a little over a year ago. So the opinion is essentially just updated to reflect that. And because it went out for public comment with the changes to incorporate Rule 8.3, we also went back and took a look at what the opinion discussed as it related to the lawyer assistance program, which is a program that the state bar offers for attorneys and law students and bar applicants who have are suffering from substance use or mental health issues. So that was clarified as well. The comments were essentially, we don't like 8.3. Which is not really relevant to this opinion. And then there were some clarifying comments, which are now here. You know, there were some comments that talked about how they didn't like how the impaired lawyer was being referred to as, you know, confused, frazzled, those types of things. But that doesn't really necessarily suggest that they are actually impaired, rising to the level that it would need to be addressed. So, you know, I'm frazzled on a daily basis. So that's probably not the best way to describe somebody in an opinion. So those are really the biggest changes. What I do want to point out, since it was just approved, is that on page 4 of the red line version is there was a section that talked about if we were to approve the proposed formal opinion 20-002 succession planning, that we would suggest revising the footnote to indicate that to provide a cross-reference essentially to that succession planning opinion. So that would be the only modification that we would likely want to do here. And let's see, Angela, if you want to keep scrolling down a little bit more, the change is shown. I believe, yeah, there you go. So it's essentially the same footnote, but basically what it does is it provides a reference to comment 5 that talks about there's a requirement in the ABA model rules to develop a succession plan. This distinguishes that and says there's not that requirement in California, but then instead references the opinion that was just approved by this committee. So these kind of, it tees that up well.
Great, thank you. I particularly enjoyed the other public comments that thought this was a brand new opinion and were newly annoyed with it. That was exciting. Anything else to add? Anyone? Erica, what are you hoping to do today? Vote it out now or?
Yeah, so same thing here. This is, in my mind, ready to go. Eleanor was the committee member who reviewed it after staff did the minor changes to it. So it would just be to, on the fly here, it would basically be to replace the language in footnote 7 to reflect the succession planning opinion. But otherwise, it is ready to be voted out, and then the board could adopt the modified opinion at its meeting.
Great. Can we vote it out and empower staff to make the footnote work, or do we?
Yes.
Okay.
Yeah, you could just say with the revised footnote 7 in the motion.
Yeah, okay. I will so move with a revised footnote 7.
Second,
I'll take the vote. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond,
Yes.
Mark, Mercado,
Yes.
Munoz, O'Reilly,
yes.
Dexter. Nikita, did you vote? Sorry.
Yes.
Robbie and Krieger.
Yes.
So it's unanimous and the motion carries.
These two go well together.
They do. It's a nice package.
We like to do it in a theme.
Well, congrats to everyone who's worked on this over the last, boy, this one's been a while, but thank you, Eleanor, and thank you, Erica and staff. Appreciate it. All right, we're gonna move now. We're ahead of schedule, so that's very exciting for everyone on a Friday, I know. We're gonna move now to item 4.2, the ethics of in-house counsel, and Cassidy is gonna lead the discussion on the latest on this draft.
Okay, so I reviewed the public comments. PREC and CLA were the most comprehensive and thoughtful and well taken. So, sorry, I keep getting dinged. So what I did was, well, one of the recommendations was that we split up the opinion, that it was too long, and split it up so that one opinion would be the 1.9, 110 analysis of former client conflicts when you are moving from one company to the other, and then the other opinion would deal solely with 1.8.1. And so so the draft that we have is just the 1.8.1 opinion, because frankly, that was the easier one to deal with. Because I didn't think there were a ton of revisions that were necessary for that portion of the opinion. As far as that opinion now, that separate opinion, as far as the first part of the opinion, what I did was, well, let me back up. One of the recommendations was to actually address the patent lawyer scenario, because we kind of touch on it in the opinion. We talk about cases that involve patent lawyers and moving from one competitor to another, where where the lawyer would be dealing with the same kind of technology, or and so I think PREC's comment was that we should address the fact that patent lawyers are subject to the USPTO conflict rules. And it's just kind of a different analysis, or can be a different analysis. So what I did there was I actually talked to Emil Ali, who's coming on board in October. He is he's admitted to the patent bar. He's an ethics lawyer, but also is a patent lawyer. So I talked to him about taking on sort of a redraft of this opinion, and maybe changing the facts up a bit so that we can address both the patent lawyer scenario, but also the non-patent lawyer scenario. So that part of the opinion, or that separate opinion, is sort of tabled until Emil can get up to speed. So I'll stop there to see if anybody has any comments, thoughts about this approach, because I kind of just ran with it after I read through the public comments. Go ahead, Brandon.
Yeah, so I think the idea of splitting the opinion in the two sections, the way you're talking about, is very, very smart, because there's so much to be said on either of these topics that putting it all together is a bit overwhelming. I have some concerns, and I've voiced it a little bit previously. I have concerns about ever saying that there are business transactions with a client to which the rules do not apply. And and I understand all the logic, and I actually don't really disagree with the logic here. I'm really concerned about, I'm not aware of anyone ever saying they can have a business transaction with a client under circumstances where the rule doesn't apply. Because I just think of tremendous mischief to be made, certainly having nothing to do with the intent of this opinion, but from such a statement. And I wonder if we are going to go down that road, if we can maybe spend a little time dwelling in the, I don't want to complicate things, but this, my concern is that there are in-house counsel in smaller startups who are exercising, maybe they're more than their fair share of influence, and who could try to take advantage under circumstances claiming that, well, the rule doesn't really apply here. I mean, maybe we should just spend a little more time focusing on the troubles, the problems. And the problem is that, I've seen this in many, maybe 3-4 times in my career where, the attorney's gonna, they get an ownership interest in exchange for doing X or Y. But they don't really do their part of the bargain. And then the firm is stuck with their ownership interest and trying to invalidate things. And I have found Rule 1.8.1 to be really powerful there. And I'm quite concerned about any idea that it doesn't apply. And then the obverse of that is just that it's just so easy to comply with, right?
I don't know about that. I mean, in this context, because it's not being complied with on a regular basis with in-house lawyers when they're hired, like in this scenario that we're talking about. And but I don't disagree with you as far as, there's some danger there, and we are kind of going out on a limb by saying it just doesn't apply, and then that's our opinion, because one of the comments was it's a thin read to read,
Yeah.
like a I was like,
Yeah, it
that's
was a CLA, right? They were quite poetic.
Yeah, very poetic. But we can't heavily rely on the ABA and the Washington opinion. In fact, or the ABA guidance, the task force guidance, because it's not binding. But at the same time, the way the Washington opinion dealt with it was almost like, of course it doesn't apply here, because this is just a fundamentally different scenario, but that we're not Washington.
Do you think there would be any utility? Because how there's that body of law, or maybe it's just in the comments, and I apologize for not being better prepared on this topic, but the idea that, like, okay, this rule doesn't apply if your client is a car dealership, but you buy a car on the exact terms that are available to the general public, right? And here, it's like, oh, these are the terms that are available to all the employees, and they aren't designed by the attorney. So it's akin to that.
Well, that's what we say. We say that it is akin to that, and we do reference that comment, but it's not a perfect fit, because it's not like, a market. It's not like the general marketplace where, that makes sense. Like, obviously, if you're a lawyer and you're buying and you own stock as part of your, your stock portfolio in your company, like that's a publicly traded company, that certainly doesn't count,
Right.
But here it's a little bit closer, you know,
Yes.
where it could count. Yeah.
I have one more thought, and I'm not trying to be snarky, but I would just draw, because I agree with you that it's not being complied with. I don't know how hard it would be to comply with it, but I do agree that it's a devastating opinion that comes out and says it must be complied with, and all of you forever have been violating this rule.
Right. I mean, like, how
But
do you?
we saw something
That's
similar
what-
in the
that's
entertainment
true.
industry with contingent fee agreements. There's all these entertainment attorneys. And I know all these people that advise those firms and say, like, I don't know why they think that the rules don't apply to them, you know, but none of them
I know.
comply with 6147 for decades. And they have all these deals. And then there was the Johnny Depp case where, you know, the attorneys have been collecting tens of millions of dollars. And then it was Judge Terry Green, back when he was on the bench in LA a few years back, was like, it's a contingency fee agreement. You got to comply with the rule or it's invalid. And LA freaked out, like, just collectively, west side of LA went nuts. But it was kind of the right answer, right? I don't know. It's tough. But I'll just
I
throw
still
that
don't
out
think it's
because
the
I
right
don't have a great
answer, though. I
solution.
mean, yeah, but because, well, I don't know. I think that, and even one of the, I can't remember which one said, you know, we agree with the bottom line of your opinion, you know, because it's the right way to view this type of, you know, stock option agreement when it's something that's given to all the, you know, all the employees. It's a standard agreement. And when it's handed to you by company's in-house counsel, you know, or existing counsel, you know what I mean? Like if you're hired as part of the legal department. I mean, it seems silly that, you know, that you're gonna, so, but anyway, I mean, we can go back and forth on this. And, so one of the suggestions was that we should flesh out, well, one, have more support for the factors in that we came up with to determine whether or not it applies. And, you know, the reason why I came up with those factors was because there wasn't one case or one authority that names them, you know, it was a kind of, you know, after looking at everything, this seems to be, you know, what the factors were, which is, you know, is it a standard stock option agreement? Does the company already have, is the company established and it has an in-house, already has general counsel that's advising it? That's the hired attorney is not the one who's drafting the agreement. It's, I'm not even looking at them, but you know, you're not a founder of the company. So so, you know, but maybe we can go a little bit further and dig a little bit deeper to see if we can find better support for those concepts. And I was going to ask Erica if we can maybe get staff involved on some research there. And then the other suggestion was to flesh out the example, you know, make a more definitive, show examples where it clearly does apply and clearly does not apply. And I thought we kind of did that with, you know, the case that talks about, you know, the lawyer who is forming a company with, you know, two buddies, you know, that case. That's where it does apply, you know, there's definitely an imbalance of power in that scenario. But I don't want to back away from the conclusion of the agreement, the opinion altogether. I think that it's, you know, I think it's right. I just think that we need to shore it up a bit more.
And again, I don't mean to be throwing a wrench in the works. I do really, really think it's an important opinion, and I respect all the work that's gone into it. And I respect the conclusion, even though it troubles me. So I'm not trying to, I'm not trying to stand in the way. It's so challenging to figure out a solution that, on this point. So I know the struggle.
Right. Dan, did you have any? Sorry, I kept cutting you off.
No, I think the challenge, and this came up, you know, last year even, related to the same issue, which we've been struggling with, is that there is no exception to this rule for particular types of transactions, period. Unfortunately, there are certain instances where it doesn't seem to fit. The purposes of the rule don't seem to apply. The implications, though, would be there are lots and lots of folks who would say, well, this is a standard deal. This happens all the time, so I don't have to do these things, right? Like, car dealers or whoever. That's the challenge. So if we flesh it out in more detail, maybe it'll alleviate some of those concerns. But if it doesn't, then I would be in favor of saying comply with the rule. It's not that hard.
Okay, fair enough. I agree. I agree with that. I mean, I think, if we can get, well, let's see. I accept your challenge.
That's right. It's a challenge.
Thrown down the gauntlet. Okay. But Erica, is it possible to get staff on board to help with some of the research, since I didn't find much on my end, so other
Yeah,
than the
I'll
Washington.
reach out to you offline and we can talk about what you need and go from there.
Okay. Okay. So that's basically it. If anybody has any further questions, I will get back to the drawing board on this one and we can talk about it again. At least we'll talk about the other opinion, other half of the opinion, or the other separate opinion in October, when Emil's there. So, all
Great.
right.
Thank you so much. And look, this is a really ambitious opinion. I really think it's super valuable.
I'm not taking anything personally. I'm not an in-house
No.
lawyer. So
No, I got it. No, I just think there's no opinion on this. And maybe other people have looked at it,
Right.
and gone, this is too hard, I'm walking away. So I really appreciate all the effort that's going in on this.
Thanks, friend.
All right, boy, I am racing us through my last day as chair, so you can all thank me later. We only have a couple things left. Should we take a little break? I'm thinking Erica, is it reasonable that we're done before lunch?
Yes, depending on what time you all eat lunch. So probably not 12, but if we took a break, I think we could be done 1-ish.
Yeah.
30 at the latest.
Show of hands that's the way to go, and then we'll take like a little break now and come back in 5 minutes and push on. Sound good? All right, great.
Raquel, was that a 10-minute break, Raquel? Is that what the 2
10's
hands?
fine.
You're on mute. I don't know. Sorry.
I was just saying 2 hands. He said 2-1. I said 2.
All right.
I was very enthusiastic.
Let's all look for 5 minutes. We'll do our best.
So
Okay.
wait, when are we coming back? I'm confused.
11.
5 minutes. Okay, gotcha. Thanks.
Should we give people another minute or two here?
I'm here, Brandon.
Oh, hello, hello. All right. Okay, well, let's jump back in. Oh, no, we're still missing a couple. Oh, we'll wait another minute here.
Sorry, I forgot I had my video off. I'm
No
here.
problem. Let's get started again, okay? Do we have to wait for the recording thing again? Are we good?
Still recording.
Great. Okay, so the next item on the agenda is this the oldest thing we have going on? It's from 2019. That's exciting. This is a pre-COVID issue. So guys, this is like a little piece of history. We're talking about 190004 client file release and retention duties. There's not much to report at all. I think the entire committee, everyone said we would go talk to the criminal defense or criminal bar practitioners that we knew and get some input. And I only knew one, and I got his input, which was our opinion is exactly right, and the people that are complaining about it are wrong. And that's just one person. So let's talk a little bit about this. I mean, we've got a draft that we all thought was reasonable and rules-based, but none of us are criminal practitioners, and so we wanted input. Unless people have gotten additional input, one of the things we could do here, we could either just make this we could vote it out for approval, or we can make a working group as we did on the AI issue, where we try to solicit some criminal practitioners to join, really get in the trenches and wordsmith with us and make sure this makes good sense. So that's really all I wanted to raise today. But Eleanor, I see you have your hand up.
Yeah, so I did talk to 2 former federal prosecutors. I think both would probably be happy to participate in a working group if we went that route. And I got feedback. I don't know if we want to go through all that feedback now, or like thoughts generally on the types.
Yeah, I'd love to,
to be
like
considered.
overview type stuff would be wonderful right now, just to see where
So-
we're headed.
The takeaway was kind of, there are frameworks that the prosecuting agencies have with respect to retention, and we might want to do some more research on what those are, because they could provide guidance for us, and they consider factors such as the nature of the conviction, the type of the crime, the duration of the sentence, any kind of follow-on effects, whether there could be an opportunity for clemency if habeas is passed, how changes in government regulations might affect the sentencing. But in general, it seemed like a lot of agencies allow destruction of records 1 year post conviction and appeal, which I was very surprised to learn. On the other hand, if somebody's got a life sentence, they keep them until they die. So there are exceptions, and finding what those exceptions are, I think would be our task if we were going to craft this in a way that allowed for that. But I did think I think my key takeaway was there are a lot of agencies that have rules on this. We might want to get familiar with them.
It seems so smart. Look, because we're operating from general principles without much contact with what's going on the ground. We might not agree with what's going on the ground, and we might think, oh, all the more reason for our opinion, but we should get educated on this. So I would propose that, oh, yes, Elizabeth.
I mentioned it, had a little discussion with a solo criminal defense lawyer and in Sacramento, who is in the process of retiring. He's been a criminal law specialist. So having a garage full of dozens and dozens of boxes, this really like hit a nerve, or not a nerve in a bad way, but I would be happy to invite him to participate from a sole practitioner perspective.
That sounds great.
I think
Erica,
that
how
would
does
be
this
great.
work? Should people who have names of potential working group admittees send them to you for you and Cassidy then to select, or how should it work?
I think that's a great starting point. This issue was actually just raised in the National Organization of Bar Counsel, and in the same way that April has a listserv, they have a listserv, and this issue was actually raised. So I have a lot of information from other states as to how they handle criminal files as well. So perhaps I can share that information with this working group.
Wonderful.
And then we can look at, obviously I believe this opinion originated because of the changes to the penal code.
Right.
Under 1054.6. So we can take a look at that, take a look at what other states do. Colorado, for example, has very specific statutory requirements, or I'm sorry, rule-based requirements, rules of professional conduct-based requirements, but it's for the life of the client, in certain instances, 8 years from the date of sentencing, in certain instances, 5 years from the date of sentencing, in certain instances, and so on and so forth. So it may be worthwhile to look at that and other types of things within that working group. But yeah, I think this is one where it may make sense for staff to be more involved in the scheduling of these types of meetings in the same way that the AI working group went forward.
Great.
One of
great. So
the things that came up that I just throw out there was when you consider potential follow-on effects, like one of the former prosecutors mentioned that motions for compassionate release are usually about how the prisoner is doing in prison, how their behavior is in prison, but sometimes it can relate to the underlying crime, and the record can be important. And I thought, well, that's interesting. So you have someone in prison wants to go see their dying uncle or whatever. Not having that record can compromise their rights or interests, which is not something I would have expected, but that could be at any point during their imprisonment. So
that's really interesting.
Yeah, I thought so too. It's
the one attorney that I spoke with, he's a solo, and he said, this is really burdensome and really annoying. And we are already doing, sort of like underpaid civic work, but we got to hang on to it forever. You guys are right. So that was he's like, I wish there was a fund that would help us pay for this, but we should do it. So it was very interesting. And I'll see if he has any further interest in, maybe he could participate further too. So if we have, the people you guys are talking about, please just shoot Erica names and we can proceed more orderly. That's great though. That's really good. Anyone else have any thoughts on this topic? Okay.
I have a question nowadays. How much is attorney work digitized versus physical files?
So that was one of the things that some of the commenters were talking about, is that nowadays most new things are digitizable, which isn't that expensive compared to what it used to be. But for instance, Elizabeth's friend who's wrapping up a career now, it's all physical from the old days, right? And it's expensive to just hang on to. All right. Well, let's move to agenda item 4.11, the request to amend the rules of professional conduct for 3.6 and 4.1, and Cassidy was going to present on this.
Yeah, so we did meet with a number of judges from the CJA, Erica, and who
I joined
gosh,
on that one.
yes, sir. Have my memory. Yes, and so
too.
I'm sorry.
Oh, sorry, Topeka and Elizabeth were there too.
That's right. God. And we covered, we basically wanted to get an idea from them, whether or not they had considered whether or not the existing rules covered these types of, so basically this is about judges who are concerned about public statements made by lawyers in social media or to the media that raise a threat of violence against them and their staff. And our initial thought was there were a number of rules that already potentially covered that scenario, which 3.6 and 4.1, and then 8.1, 8.2 is 8.2 and 8.4. Yeah, or 8. Anyway, so yeah. I'm like giving myself a quiz for no reason. And so I recall, and Erica, correct me if I'm wrong, one of the things that we were kind of concerned about was, obviously the free speech issues, but, whether or not they would include, truthful but inflammatory statements, or are they just limiting to, prohibiting false misrepresentations and, that are directed or are about judges. And they said that, they only want to encompass false statements, right? If with any revision of the rule or any opinion, I think they were open to opinion and an ethics opinion. So, we didn't land on anything specific as to what the plan was, except I was going to explore whether or not other states had address this through either revisions or ethics opinions. And I did send an email around the April listserv, post a question on the April listserv. I did that this morning. So I did get some responses so far. There is an ethics opinion out of Michigan that is probably not very helpful or would really address the concerns here, because it was about the fact that judges should recuse themselves when there are threats against them, because, it raises an instance of they could become biased against a particular party. So it's more about, it was more about the judges, what the judges' duties were in recusal, as opposed to actually preventing the threats and public statements in the first place. And then, somebody raised the fact that there is federal law on this after Judge Solis out of New Jersey's son was killed at her home. But that legislation really just talks about protecting the privacy of the judges, their home addresses and that sort of thing. So there still is kind of a gap here. And in that there's not specific rules or opinions so far that we've seen that addresses these types of public statements. We have another meeting next week with them. And I think we're going to meet with OCTC, because the question there with the existing rules was, we kind of want to get an idea how these are if they are false statements made and they are threatening, are they being prosecuted, and how will they be prosecuted, and how do they get around the free speech issues? So that might be illuminating. And then one person commented on the listserv that she is defending some matters. I think it was in New Jersey, where these types of statements are being prosecuted by the New Jersey State Bar, but obviously she couldn't go into any detail about her matters. So, but it'd be interesting to hear more about those types of prosecutions. So that's my report. Anything else, Erica, Brandon, Elizabeth, that you recall from the meeting?
I'll just say that I think CJA's perspective was that they do think that this is worthy of a specific call out in a rule, as opposed to, we did kind of go through the analysis of this could be perhaps prosecuted under several of the rules that Cassidy already mentioned. And they still thought that it was important enough to perhaps have its own rule or own comment in an existing rule to indicate that it would be a violation of one of those rules. Versus being in an ethics alert or an ethics opinion. So at the meeting next week, as Cassidy mentioned, OCTC representatives will be there to discuss if this has come up and how it's been, considered and possibly charged as such. And then, there are a few cases outside of California where this has been charged and resulted in discipline, but they're kind of few and far between. So I think that may be relevant, but not so necessarily.
Elizabeth?
Yeah, preliminarily, I I'm in agreement with the CJA's position as we were kind of drilling down and looking at the rules that do exist. I don't remember which one it was, 8.4 maybe. There's a comment in one of the rules about referring to the Business and Professions Code and lawyers' duties to speak out against this kind of
Right.
conduct. Which I was like, okay, they're calling out our duties to rise up against this kind of conduct in the rules, but not to not engage in the conduct in the rules. And so that to me just doesn't jive. It doesn't score. And I think wherever you're referencing that has either a rule or a suggestion that the judge be required to recuse themselves, that is the surefire way to get more of these comments made.
Right, right.
Because,
right.
you know, it's going to be completely forum shopping and getting to DQ a judge surreptitiously by engage as an incentive to engage in that kind of conduct to begin with. So, you know, we have a lot of rules that overlap and there's redundancy. And I think it is kind of an epidemic level. Politics aside, I could envision it getting much worse soon, depending how things go in the next few months. So I think we should really give serious consideration to what they're asking us to do.
Agreed. Yeah, I forgot about that. The comment, that rule. I mean, we hadn't really zeroed in on that before we had that meeting about, you know, the duty of lawyers to actually call out, you know, those, but it's, you know, it's, nobody knows about it. You know what I mean? It's something that, you know, it's not even really prosecuted at all. So that's something we can talk about next week as well. Brandon, did you have anything?
No, I just continue to believe it's a very worthy subject for exploration, but an exceptionally challenging rule to conceive of that is appropriate and not violative of anyone's free speech rights and things like that. I think it's a really tough ask. I was really surprised too by the judges talking about the ways in which their judicial codes prevent them from defending themselves. Because my first impulse was, you know, if you've got a litigant, a lawyer who's out of control, you sanction them, you smack them down, you do something, right? And maybe they should be looking at their codes. I don't know.
Yeah, I don't think that's going to happen. That's like the sanctions is like the absolute last thing you're supposed to do as a judge. And, you know, it's a serious thing, even for I mean, my significant other's a judicial officer and he handled one of the Trump Stormy Daniels cases. And when his decision came down, finding the signatory to the hush money contract to be a pseudonym for Donald Trump, it made headline. It made all of the national news. It was all over social media, and we were looking over our shoulders for weeks. One, you know, it's really an independence of the judiciary issue on top of just the threat of violence. I mean, and think of at times how many judicial officers are making really noteworthy, incredibly challenging and difficult decisions every day. I think finding a way, there has to be. If we already restrict free speech by making it an ethical violation to make misrepresentations to the court,
Right.
you know, and clearly if it's about a judge and about a proceeding, it's within the ambit of that attorney's practice as an attorney. It's not just, I mean, maybe that's the narrowing language that has to be. It's not just in their everyday life as a citizen discussing cases in general or judges in, but in a specific matter that they are a party to or involved in. We already limit speech when it's false. So it seems to me there has to be a way to be able to do it.
Well, and I think, you know, if we are going to go down the route of a new role or a comment or whatever, that, yeah, of course, we're going to focus on, making sure it's narrowly tailored. So it's not, unnecessarily restricting free speech. But the fact of the matter is it's going to be challenged probably, and then it'll be up to the court to define those parameters or, say that it's okay or not. But, yeah, I mean, I don't think we should, I guess I'm gonna say, I don't want to say, I don't think we should worry about the free speech issue, but at the end of the day, that will be, for a court to decide. Because it's, we would be basically, making law that has to do with free speech. You can't avoid it. So. Because we're talking about public comments.
Mhm. Anyone else have any thoughts on this? It'll be really interesting to see what comes out of next week's meeting. And I want to hear OCTC's thoughts too.
Yeah.
All right. So we're going to move on to item 4.12. Erica, what possible new opinion and advisory topics are we looking at?
All right, so normally we typically do this about every 6 months, but at our June meeting, I said we would probably do it sooner because the individual who submitted the request for an opinion did it about a day or two before we had that meeting. So the request here, there's only one, it was in your materials, but essentially what occurred is that a complaint was filed with OCTC alleging a violation of Rule 4.2, which is communication with a represented person. And based on the information provided, it appears that OCTC declined to move forward with charges or even investigation because of Evidence Code 1158, which deals with obtaining medical records from a doctor in regards to a claim or an injury matter. And so what they basically said was that because 1158 allows for the party or the patient or their designee to obtain those records, that the lawyer could reach out directly to that doctor as opposed to going through their lawyer, the doctor's lawyer, even though the opposing counsel knew that the doctor was represented and they had an email trail evidencing the fact that the lawyer was representing that doctor. So that's essentially it. It's really a question of whether or not the evidence code provision preempts 4.2 or not. I'm not sure that the committee has taken up anything of this nature in the past. It's kind of an interesting segue because the next item for discussion is also kind of a preemption question that we may get into as well. But so that's the opinion topic. And, the committee could decide that they want staff to kind of work up an initial issues outline. They could, if the committee wants to appoint a working group, they could, or the committee could table because there's interest, but not enough bandwidth, decline to take up the issue as well.
What is staff's bandwidth for doing a really preliminary issues outline on this?
I think so long as it's not necessarily by next meeting, I think there's certainly bandwidth to do it. I would like to, what I think is more significant than doing kind of the background research, we can obviously do the case law research, but I'm not sure that we have addressed rule preemption issues before, and I'm not necessarily convinced that's within the scope of this committee.
Is that more of a legal question, perhaps?
Yeah, it doesn't seem like it
Yeah.
would be. Yes.
But I do think, I mean, have we opined much on contacting represented parties? Is that something that the committee has weighed in on before?
Not in recent history. There's 1993 opinions. I think the most recent one was in 2011, which was implied consent to communication with a represented party. There's a recent ABA opinion that does talk about this. I think from this year or late last year, that talks about if you BCC or if you not BCC, if you CC your client, that you are implicitly authorizing communication with your client because you've copied them on the email. So it's been addressed, but definitely not in this context.
All right, does anyone find this intriguing at all?
Well, maybe just the initial question would be whether this type of a preemption issue is something that's in our scope.
Yeah.
Be good to know. It doesn't seem like it is to me, but
Unless it's very clear based on existing case law, which I would assume it is not, because then OCTC would have gone one way or another in addressing it.
Right.
Right. Well, if we can look into that very briefly, because I don't want to burden staff if we don't even have a huge expression of interest, but if we can talk about it next time perhaps, or the one after. Just the answers to the sort of preliminary questions, that might be great. So the next item is consideration of an advisory or opinion on abortion access and legal advice regarding abortion access. And I think Erica's going to talk a little bit about where we're at on that, but we just have to make some decisions about whether this is within our wheelhouse and how we might proceed if we think it is.
Sure. So we had public comment this morning that referred back to the work that was done on this in March. So staff did kind of an initial issues outline, essentially, that brought up all of the relevant rules of professional conduct and business and professions codes, and then also raised the COPRAC opinion 2020-0002, which is the marijuana opinion, basically. And so there was some research done at that time. At our March meeting, there was a pretty good discussion about the California constitutional right to reproductive access, and whether that provision would preempt essentially the Business and Professions Code statute on this issue. And I think that's kind of where we ended, if I recall correctly, that's kind of where we ended the conversation, but there wasn't a ton of interest at that time of interest or bandwidth, again, in taking this issue up. So, this is another one where there is a preemption issue. There is case law in California that does address preemption, and it talks about how statutes, need to be, can be construed to not violate the California Constitution. So there's case law on which the committee could make a decision here. But essentially what it comes down to is, in other jurisdictions, if this is a crime, if an attorney is convicted of that crime, California does have reciprocal discipline by statute. And then the fact that the crime is not a crime in California is an affirmative defense. But based on existing statutory authority, it appears that a licensee, if they were prosecuted for this, would have to provide that affirmative defense as opposed to not being charged in the first instance. That is assuming, of course, a big assumption that OCTC would move forward with prosecution in this case. As we've discussed in other instances, historically, OCTC has not issued a decline to prosecute type of notification where they would indicate that, hey, we're not going to be prosecuting these types of crimes, particularly because here there is a statute. So it would be going against what's in the Business and Professions Code in regards to reciprocal discipline. But then, of course, as I just mentioned, there's the California constitutional issue as well. So it's very interesting, I will just say, from an intellectual standpoint, if nothing else. I am also on the April listserv, and there's been a lot of conversation about this topic as it relates to moral character and admissions of soon-to-be attorneys over the past several weeks. And someone did mention in the listserv that there is a California local bar association that may be working on an opinion on this topic. I am not on any of those local committees, and so I don't know if any of you are aware of a if I'm guessing it's LA.
It's LA, yeah. And,
so it may be being addressed by a different committee, and so that doesn't preclude COPRAC from addressing it as well, but again, going to time and effort if it's already being addressed somewhere else.
Well, and I apologize if I made this exact comment last time we talked about it, but in a so if we have a statute that is the issue, and we have a political climate where it should be possible to address the statute directly, that may be far preferable to an opinion working around a statute. just my 2 cents.
Yeah, and I think, Brandon, I think you or someone else raised that at the last time we discussed this, and there are that went into effect in 2024 after Roe v. Wade was overturned. There are numerous statutes that came out effective January of this year that address this in one way or another. They just don't happen to address this issue as it relates to attorneys. And so it seems like this was an area that might have been missed when all of those statutory changes went into effect. Most of them relate to, for example, physicians will not be subject to the California Medical Board for discipline for providing access, those types of things. So I think this is just not necessarily something that was on the forefront of everyone's minds when the changes.
Right.
This issue came up in our 8.3 drafting, and isn't there a footnote that accepts this situation from the reciprocal or from the reporting requirements?
Yes, so, but that's the duty to report another's misconduct. And so that's the distinction there, is that there's nothing that says that this is not misconduct. It's you don't have to report somebody else's misconduct for it.
Yeah, right.
But it's a BMP code trigger, not. Yeah, okay. It
I'm
just
just,
seems,
the argument that I would make is that if you don't have to report somebody else's misconduct on it, then it should be a basis for discipline generally. But that's the question itself. Should we go that far to say it? What is Prec doing on this? They're doing a full opinion?
they are the really preliminary stage where they're just like coming up with some fact patterns and talking about it. So I don't know where they're gonna go. I'm not on the subcommittee there, but they're at least gonna be engaging.
My 2 cents, it seems like trial counsel would want to have the complete discretion about whether and when to prosecute these if they ever came up. And I would be hesitant to make a blanket rule that impedes on that in some way, especially because it's a statutory issue. They're making individual decisions in individual cases that they should make.
Right. Well, I'm not hearing a clear path forward or a huge amount of enthusiasm for such path. Should we table this and talk about it? We're gonna have some new members next month. Raquel.
So I'm curious the reaction to the public comment based on what's being said. Because she seemed like she had a great concern and a high level of urgency. So it didn't seem like she thought it was an intellectual
Yeah.
exercise, but that it is something that if possibly it's in her mind as she's going about her and other attorneys' work. So I'm
Yeah.
just reading into, what I heard. So I'm just curious, based on the things you said, Erica, how do you relate what that person is saying to how you're saying? And I guess in some way to you, Dan, as well, who said we shouldn't probably do anything, just let it play out inside of the legal framework that exists.
Well, I would be interested in taking a look at it. I think in March, my conclusion would be that the California Constitution would preempt anything else to the contrary, period. So I think if it were litigated, that would be the result. And that may be litigated.
Yeah.
Right. So, sorry, go ahead, Brandon.
Oh, I'm sorry. I just also I don't know because I think the concern is 100% legitimate. I just wonder, is there like a legislative liaison committee that it seems like something that the legislature would just fix if you get it on their radar, and then it's like really fixed, and it's not just us opining about a statute. It's the statute would be somewhat different. But I don't know how that works, but it seems like that's the fix to me. And I say that there's a million things that the legislature will never fix that we complain about, but this is one that I think they would move quickly.
So to go back to the statutory issue here. So let's just for step aside from the Constitution for a minute, and let's just assume that there's only a statute, which is maybe an exercise in futility, but let's just do that for a moment. The statutes within the State Bar Act, the Business and Professions Code sections, most of them are not discretionary. And so, there's prosecutorial discretion, but there's an argument to be made that because these statutes exist, there's no discretion here for the prosecutor's office to take. So if we just kind of go through them high level, there's 60680, which requires lawyers to report their own convictions. So if a lawyer who is licensed in 2 jurisdictions, one of those jurisdictions makes this a crime and they are convicted of it, or if there's a felony indictment regarding it, they would be required to report that to in California to our prosecutorial authority. There's also other statutes within the State Bar Act, 6102, which talks about the need to move forward a criminal conviction through with the notice of disciplinary charges. It's a separate process than other discipline in attorney discipline in California that exists. So there are certain requirements within those statutes that seem to suggest that it's possible that an attorney could be at least charged with this type of conduct if they were, again, convicted of a crime in another jurisdiction. It's possible they could have an affirmative defense or several other defenses and so on and so forth. So there's 2 things that could happen here. The committee could examine this issue, and based on the California Constitution, they could find that the statute would not apply in this situation based on the constitutional provision, and the opinion could say, this is okay to assist somebody in reproductive access in California, and you won't be subject to professional discipline for it. The opinion could also not say that, and then those who are asking for this opinion could end up with something that they really didn't want, which is an opinion that says you will be disciplined for this in California. And I don't think that's consistent with politics in California, frankly. But based on the statutes that, again, don't contemplate this, that could be the result as well. So I think maybe that's the hesitation there, is that the result could lead to unintended consequences based on those who are requesting it, that a legislative statutory fix would avoid.
Which leads me to my question. I was just trying to look up the California Conference of Delegates. Do we know if they've taken anything up yet? I was trying to see online if they had, and the resolutions, you'd have to read through everything, but I'm wondering if they might have already started that process. And they know they're meeting in October, so. I can look it up and return back to that issue. I just don't, it just hit me today because I'd received a reminder about the Conference of Delegates this morning. And so I was trying to see if they might be
That would be
doing
helpful. That would just be good to know. That would be good to know.
The challenge that I had was trying to figure out in the scenarios that Erica described what we would be doing. And the one scenario that makes the most sense is to say that the statute wouldn't be applicable in these circumstances, but I'm not sure that we've ever done that.
I'd be afraid. And what if the OCTC disagrees with us? What have we done to the help? I don't think they
kind of what
would.
I was thinking. They don't probably want us to start carving out exceptions to the reciprocity.
Yeah.
They may just say, we will handle this by not prosecuting these if we decide that's appropriate. But it's an important issue. I think it should be resolved by the legislature. I don't think if it were litigated, there would be any question how it'd be resolved. Where we got in March is some other state or California, the state bar is going to discipline you for doing something that is prohibited by the Constitution. That doesn't seem likely.
Right. So, okay. So the state bar has a legislative liaison, right? Like they talk, but COPRAC never says, we think, does COPRAC have any history of saying we suggest a change in this statute on this point for normative reasons, or something like that?
I'm not not aware of CoPrac doing that. The closest thing I could think of is the 6068 attorney-client confidential information. I'm trying to recall, there was a separate standalone committee that addressed that. I can try and look back and see. I can dig through the archives and see if that's ever occurred.
I think it would be really useful for us to talk about this again at the next meeting or a future meeting, because my reluctance has nothing to do with how important I think the issue is. I just don't think I don't think we're the tool to address it. I think, but I'd like to learn more. Does anyone else have any thoughts on this topic?
Could we
Erica?
just reach out to the legislative liaison? Is there an office we could reach out to see if they would be interested in a recommendation or receptive?
Do you know Erica?
The State Bar? Sorry,
Just-
Eleanor, in the State Bar?
Yeah.
Yeah, I can reach out and see how they would want to proceed. And if CoPrac wanted to, we have the State Bar has legislative priorities annually that are established and set by the Board of Trustees. And so that typically occurs initially, I believe the first meeting at which those are proposed is the January meeting of the Board of Trustees. They're essentially their planning meeting. And then they are updated and amended as the year progresses before the board. So that's a possible avenue that CoPrac could essentially write something up in support of moving this forward.
It sounds like there's interest to do that. It would be good to know if they're receptive and what form they'd want it in.
Yeah.
Completely agree. I think that's a great idea. Well, unless there's more on this topic today, Erica, we're not doing any cryptocurrency this month, right?
No, we are not. Hopefully October.
I think we're done. I think everybody should have a lovely Friday, and I look forward to seeing almost all of you at the October meeting, where I will be not voting and not talking very much. So it's going to be really good for all of us.
Thank you, Brandon.
Thank
and
you all.
everyone.
What's the
Wait,
date?
and then
What's
the
date
next
of
meeting
October?
is in person, right?
Yes.
What's the date?
The
Oh.
18th.
Yeah, in LA, October 18th.
LA. Yeah.
LA. An email will follow pretty shortly after this meeting today to remind everybody of where, when, and how to book travel if needed.
Great. Thank you all.
Thank Erica.
Thank
Thanks,
you.
Brandon.
Bye.
Thanks.
Bye.